We go to Panama City, Florida for a pretrial hearing. 33-year-old Devontae McCoy has been charged with fleeing or attempting to elude law enforcement, reckless driving, improper license plate, and no vehicle registration. A year earlier, police say McCoy was driving a car with plates that were not registered to the vehicle. And as they attempted to pull him over, McCoy fled the scene. But officers caught up with him later that night, where he was arrested and charged. McCoy was released on $26,501 bond, but after he missed a court appearance, a warrant was issued and he was taken into custody. Today, he appears before Judge Brantley Clark to discuss next steps in the case. The state prosecutor is Frank Sullivan. McCoy has chosen to represent himself.
McCoy is before the court pro se. Mr. McCoy, you understand at any point in time, you can ask an attorney to be appointed to represent you, and one will be appointed to represent you, no charge. You understand?
Yes, sir.
All right. Mr. McCoy?
I was coming to address a couple of motions that I have filed that I was requesting over this year period.
Okay.
The video from the Sefco gas station that doesn't exist.
And the body cam from the FHP and the body cam from the Bay County SID.
It seems McCoy believes there's video evidence that could help his case, including security footage from a nearby gas station and body cam video belonging to law enforcement. The state claims they've already shared any existing evidence with the defendant.
Judge, we've had this hearing 5 times already.
Okay, I understand that. I'm just addressing that, Mr. Frank Sullivan, because without this evidence, that's prejudiced me in preparing for my trial.
Okay, what evidence don't you have?
The video from the Sefco gas station.
Okay, that I've already ruled on that. It's part of the record, and it's ad nauseum part of the record, okay? I'm going to deny that motion.
I can't proceed and have a fair trial without this evidence.
So?
Judge, all of the video in this case has been provided.
No.
Listen.
Mr. McCoy requested the SID body cams. We reached out to SID. They did not have body cams at that time. We asked for any dash cams that were potentially used. There were undercover vehicles. There were no dash cams for the Bay County Sheriff's Office. All the video that was involved in this case has been provided to Mr. McCoy.
All right, motion denied. Anything else, Mr. McCoy?
Yes, I got a motion to dismiss for spoilation of evidence that I would like to be heard.
I'm going to deny it. That concludes the hearing.
I'm not done talking, Mr. Clark. I'm trying to prepare for my trial. I'm trying to present.
October 6th at 8:30.
Really can't expect me to go to trial by denying me my sculptory evidence.
All right. We'll see you October 6th.
And deny me all my evidence and force me to
October 6th. You're going to represent
I
yourself.
filed all the proper motions.
Do you ever see the lawyers arguing with me like that? No, sir. Whether I'm right, whether they think I'm right or wrong, they don't argue with me. So that concludes the hearing.
Look at everything you already done to me.
Hey, man,
I'm trying to help
Mr.
you.
McCoy?
Hey, man, you need to stop that shit.
Mr. McCoy? You're getting real close to not being able to represent yourself because you can't do it competently. That's enough. All right, Mr. McCoy, bring it back.
McCoy is brought back before the judge.
I don't need you to say a word, but I am going to tell you, any more outbursts last night, you will not be able to represent yourself again. You understand? Take him out.
I'm trying to defend myself.
All right. Mr. McCoy, I'm appointing the Office of Public Defender to represent you. I'm going to find that you are not competent to represent yourself. We're leaving on October 6th.
Don't treat me like that.
3 weeks later, McCoy pled no contest to fleeing or attempting to elude law enforcement. He was sentenced to 6.5 years in prison with credit for 235 days time served. We head to Miami, Florida for a bond hearing. 18-year-old Gianni Sosa Hernandez has been charged with criminal mischief. 2 weeks earlier, Sosa Hernandez was at a local mall with a friend when he spotted a fake alligator on display in an off-limits area and decided he wanted to wrestle it.
Hey, bro, what's up, man? What you about to do?
Okay, man, you know how we coming, man. That's something.
You know, man, coming. Hey, no! RKO!
The defendant was mimicking a well-known takedown move known as an RKO, made famous by professional wrestler Randy Orton.
Hey, pin that boy. 1, 2, 3.
Sosa Hernandez left the mall before security and police learned about the incident. He later posted the clip on social media. And 2 weeks later, after a witness from the mall identified him as the alligator wrestler, Sosa Hernandez was arrested. Today, he appears before Judge Renatha Francis.
Gianni Sosa Hernandez. Gianni Sosa Hernandez.
Yeah, he's back.
This is not the first time Sosa Hernandez has appeared before Judge Francis. The judge had seen him the previous week because of another RKO stunt where Sosa Hernandez tried the same move on the principal of his high school. But this time, the outcome was slightly different. Sosa Hernandez was arrested for battery and spent 2 nights in jail. When the principal decided to drop the charges, the case was dismissed.
You're back, Mr. Sosa Hernandez.
Good morning, Your Honor.
Now it's up to Judge Francis to decide if Sosa Hernandez will be released on bond for his alligator wrestling stunt.
You're being charged with criminal mischief. What's the allegations this
So,
time?
based upon the arrest that he had last week, they were able to identify the defendant from a video posted on social media where he jumps over the wooden pedestrian barrier at the falls, grabs an alligator display, throws it to the ground, and then does an RKO, which I guess is the defendant's signature move on this alligator. The alligator was damaged, and it states that the total cost of the alligator was $3,690. That seems a little expensive. I don't know how much alligators cost.
The judge asked for the state's recommendation.
The state's requesting a stay-away order on the falls.
Stay away from that location. You understand?
Yes, ma'am. Sorry, yes,
Falls
ma'am.
Shopping Center at 888 Southwest 136th Street.
The public defender then offers his recommendation.
But Your Honor, give me pre-trial then.
That's what Your Honor did on the previous case.
Pretrial? Okay. Pretrial services.
With the stay-away order from the
Yeah,
shopping center.
with the stay away order, most certain. Okay, no hold.
Finally, Judge Francis offers the defendant some advice.
You've got to find something else to do. I mean, really, this is just, you're just gonna keep coming back here and keep being a media sensation for all the wrong reasons.
Sosa Hernandez was released on pretrial services and pled not guilty. The case was ultimately withheld. In Florida, judges can withhold adjudication of guilt, meaning Sosa Hernandez won't have a conviction on his record if he stays out of trouble. A judge did mandate he pay $403 in fines, which he did, but he did not have to pay for the damaged alligator. We go to Tampa, Florida for the trial of Jeremy Guerrero. The 32-year-old has been charged with DUI manslaughter. 2.5 years earlier, Guerrero was driving with a passenger in his car when he struck another vehicle, sending it into a tree and killing the driver. 57-year-old Maria Perez, a married mother of 5. Guerrero and his passenger suffered no major injuries from the crash. When police arrived, they asked Guerrero, who was high on methamphetamine, to do a series of sobriety tests. After failing the tests, police took Guerrero into custody and drove to a nearby fire station to do a blood test. On their way, officers told Guerrero about the accident.
We hit another car. You're off the road to get a tree.
When Guerrero learned that a woman had died in the crash, he tried to place the blame on his passenger, a woman named Mary.
She's messed up. She was the driver, and it's her car. Was high. You know what I mean? And she insisted on driving all the way back.
But police claimed Guerrero was the driver, and he was officially charged. Guerrero pled not guilty. His lawyer argued that because Mary's DNA was found on the driver's side airbag, while Guerrero's was not, that Guerrero could not have been the driver. The trial ended with a hung jury, but the state decided to try him again. Today, as Guerrero's second trial gets underway, prosecutors put the arresting officer, Joseph Angelici, on the stand.
In my opinion, this individual is impaired beyond his normal faculties to operate motor vehicles safely.
During a break, Guerrero, who's been disruptive throughout the trial, directs a comment at the officer, getting the attention of Judge Michael Williams.
DNA don't lie. They're manipulating the trial.
It's disruptive. I let it go the first time. It's not going to happen a second time.
Yes, sir.
But later, the judge catches Guerrero making gestures from the defense table.
You're not going to gesture to anybody again.
Yes, sir. Absolutely.
Are we clear?
Yes,
You
sir.
said you were clear last time. Are you clear this time?
Yes, sir.
When things calm down, the prosecution plays an important piece of evidence for the jury.
You're going to see the defendant get into the driver's seat, drive away from the gas station.
When Guerrero takes the stand, he maintains his innocence. He even tries to explain away the surveillance footage.
So we make it to about a couple lights down, and I pull over to the side of the road and quickly switch seats.
Were you driving the car?
Hell no.
But the prosecution introduces a new piece of evidence that was not part of the first trial. A phone call Guerrero made while in jail.
I chose to drive her home. She started fighting with me, pulled the steering wheel, and let me run into that other car.
This time, the jury returned with a unanimous verdict: guilty. Guerrero was sentenced to 20 years in a Central Florida prison, plus 10 years of probation. Mary, the passenger in Guerrero's car that day, was never charged in the incident. Next, we go to Miami, Florida for a first appearance hearing. 38-year-old Felix Goldstein has been charged with misdemeanor battery, and after his arrest, Goldstein allegedly got into a fight in jail, picking up a second battery charge. He's pled not guilty to both charges. He was initially granted bond of $1,500, but failed to post it, so he's been in the county jail since his arrest. Today, Goldstein appears before Judge Carmen Cabarga, who will decide if there's probable cause in his case and if the bond amount will be adjusted. Representing the state is Nessa F.
State. So it looks like in this affidavit, it states that he pushed the victim first. The defendant's in custody on a misdemeanor battery, which owner set a $1,500 bond on this case.
As the judge looks over the charge, Goldstein argues his case, not realizing his microphone is muted.
I do find probable cause, and I'll give a bond of $1,500. Anything else? No, Judge.
Because of the jailhouse incident, Judge Cabarga sets a second bond for Goldstein for an additional $1,500, increasing his bond total to $3,000. But just as the judge is ready to move on to the next case, Goldstein unmutes his microphone.
All right, sir. Thank you.
Hello, can you hear me?
Same facility. Stay.
Hello? Ma'am, can you hear me now? I don't think you could hear me before.
No, I can hear you now.
I was saying, I'm Goldstein.
Yes.
I don't want her or anybody representing me, any lawyer at the moment.
Okay.
And I don't want to give in personam jurisdiction to the court. So therefore, I'd like you to dismiss the case.
Okay.
In personam jurisdiction is a legal phrase that basically means the court has jurisdiction over a defendant.
And also, I have another case that I was going to ask you to also, I don't want to give in personam jurisdiction to the court. That way, I want you to dismiss basically all the cases that I have.
All right.
And then I would like immediate release also.
I'm not doing that at this time. Yeah.
Ma'am, you just agreed that you were going to dismiss the case.
No, I did not, sir.
The defendant seems to have his own interpretation of the judge's responses.
I want you to dismiss basically all the cases that I have.
All right. You are to stay away from. Do you understand, sir? As best as you're.
No, I don't understand. I explained to you. I know all about the whole 13th Amendment
You are to
and
stay away from him, sir. Okay.
13th.
You can.
Ma'am, I got another reason why the case should be dismissed then. You don't have a valid charging instrument.
All right, sir. Thank you.
The case is dismissed then?
Right, the case is not dismissed, sir. I set a bond of $1,500, okay?
Okay, I got a question about my other case then.
I can't answer a question about the other case. I don't have that in
No,
front
they're
of me.
turning off my, you can't go back on your word. You already explained that you were okay with dismissing this case.
No, you misunderstood.
I explained right away that I don't want her representing me.
I understand that, sir. It's a first appearance. I just found probable cause on the charge of the case that's before me today, okay? Thank
I don't
you.
understand that, ma'am. You can't go back on your word. Let's look at the charging instrument.
Sir,
But
we're
look,
finished for today, okay? You'll
what
have-
about my other, okay, I got a question. Listen, I got another case. Well, I would like to take care of that case. Look, let's rule fairly. This is ridiculous. You know, there's a lot of cruel and unusual punishment. You just
We're not
agreed.
here for that at this time, sir. That case will be addressed by a different judge, okay?
I would like you to take care of it. That whole case is all
Thank you, sir.
crazy. When is my next?
Sir, we are done for today. Thank you.
Despite Goldstein's lack of success at this hearing, both of his cases were later dismissed due to lack of evidence. Next, we're in Miami, Florida for a bond hearing. 30-year-old Travis Green has been charged with petty theft and battery. Today, Green appears before Judge Mindy Glazer, hoping to be released.
Hi, Mr. Green. Good morning.
But Green has a lengthy criminal record dating back to 2011, including charges for grand theft and burglary.
Sir, you were arrested for petty theft and battery. I will appoint the public defender's office for you.
Before discussing bond, the judge has a question about the charge.
This is at the Family Dollar store.
Yes, ma'am.
He said he went into the store, picked up multiple items, and then walked out of the store not paying, came back with a pliers tool in his hand, screaming and yelling in the store. So if he's using force, isn't this a strong-arm robbery?
The public defender, Renee Gordon, disagrees.
Judge, I don't think it is, given that the defendant hit a product out of his hand, causing the product to become loose. I'm not sure that would even qualify for a battery, as it's not clear that the man was actually touched.
Then he came back in the store a few minutes later with a pliers tool in his hand, screaming and yelling.
He had him in his hand, but he didn't say he did anything with the pliers. Didn't even say he made any threats. So
All
at
right.
this point, I do think what the court has is definitely a petty theft. I'm not sure about the battery.
I'm never going to that Family Dollar again,
Yes.
ever in life.
Judge Glazer checks in with the prosecutor, who appears off camera.
I know what the state's seeking. You want a bond?
Yes. There's nothing specifically said that he touched the person. Said he touched the product, and the product.
The product was in the person's hand. That is a battery.
When the two attorneys are done arguing, the judge makes her decision.
So count one, there's probable cause for petty theft, $500. Count two, battery is $1,500. Have a good day.
But the public defender isn't quite ready to give up.
Judge, would you consider pretrial services if he has a good address and a phone number?
Not on these priors.
Judge, the priors are somewhat dated.
State would object on the fourth.
State's objecting. Yeah. Well, I'm concerned because he hit the guy. Really should be a strong arm.
I didn't touch the guy at all, Your Honor. I promise you.
Oh, no, not the guy, the package out of his hands.
Does not say that he came in and hit anyone.
Your Honor, what concerns the state is that after leaving, he came back with pliers in his hand, screaming and yelling at the people in the Family Dollar
But it
store, not
doesn't
allowing
say
them to
he
do their
used the
jobs.
pliers to do anything. He may have just had pliers with him. It doesn't, sir, it's okay.
Judge Glazer ultimately sticks with her ruling.
I'm not giving free trial. It's a bond. Let him post a bond. It's $2,000. 500 count one, 1,500 count two. Have a good day.
You nasty.
No, you nasty. Hold on.
Miss Courtney, let it go. Not worth doing a contempt, just let it go.
On his way out of the courtroom, Green smashed a glass and was charged with criminal mischief. The next day, he was given an additional bond of $1,000. Green was eventually released after posting all of his bonds, and his cases are pending.